attorney. She practices in estate planning and probate, and she's going to teach you a little bit about about what goes on here, both in Fort Bend and just in general. Go right ahead.
Okay. So I'll tell you a little bit about myself. My office tends to handle a lot of family conflict. So whether that be some family law issues, or a lot of times family law as it correlates to probate and guardianship issues, special needs and Medicaid applications. But mostly my practice is about 60% litigation and 40% transactional. So most of the time I do this presentation, it's for attorneys, which is why I'm not going to read this to you. But what you are going to see, I teach a lot of lawyers who are learning how to do probate, and what you have in front of you is what I would tell them. So it's really tips and tools, really practical steps on what probate looks like. And so we're going to kind of walk through that, and then at the end I'm going to talk about estate planning a little bit, and then I'm going to let you guys ask questions all the way through. The goal for me is to help you walk away with information that's useful and beneficial to you. So please feel free to stop me. If you ask me something that's super way off base, I might just say, let's talk afterwards. But that's okay, because the goal, you came here to get information. I'm really hoping I can help you do that. My office is in Katy. I've worked with Andrew for a long time. I'm on the law library committee here, so really do believe in the service that Fort Bend County is really blessed to be able to provide. You may not know that, but not every county has this type of availability. So these are your tax dollars at work, and it's really amazing that we can do this type of setting where you can just come and informally get information that's, hopefully quality. I know some of the other stuff today is quality, so good. And that's my associate attorney back there. That's Dante, so she's kind of helping too, and y'all can chat with her if you'd like to. So let's kind of get started. That's me, and I might not be good at this. So this is really true. So one of the first steps to the whole probate in general is picking the right type. And does anybody know who Susie Orman is? Susie Orman? Mm-hmm. Yes. So she is like my frenemy. I love that she talks about probate. But Texas is one state that is, there are 4 states in the union that are really probate friendly. And so most people who come in my office, they tell me, look, somebody passed away, we need to do something, but we just really don't want to go through probate. We heard it's really expensive and it's really time consuming. And the truth is it's really, really not. I would say the average probate case in my office is anywhere from 2 to 6 weeks. We get in, we get out, we move on. Okay, that's not true if there's some other issues going on, but a standard probate of a will is pretty easy. So we're not afraid of probate in Texas. But when we talk about probate, it's important to know there's not just one kind. So we're going to talk about different types of administration. And to help you kind of understand that, I want to talk about the way we give property away. Because this is a really important foundation, and if you don't understand this, everything else we talk about is not going to make sense. So we can give things away while we're alive, right? We can just give you a check, and that's a great day. That's called an inter vivos gift. I don't know why we still use that fancy word. It's silly, but we like it in Texas. It's called a living gift. It's a gift you give while you're alive. So it's the first way we give something. Second way we give something after we pass away is a testamentary gift through a will. So we have a will, and it says, I love my husband, and he loves me, and when we die, we're going to give our things to each other, and then when we both die, we're going to give things to our children, all right? So that's the probate part of the will. The third way we give things away is by contract. So every time you put a beneficiary on an account, or you add a transfer on death, or a payable on death to something, you're giving it away by contract. And then to tell you how important this is, if you have $100,000 in a bank account and it is payable on death to a child, okay, because maybe that makes sense. But then you also have a will, and your will gives everything to your spouse. You've really affected your estate plan, because the will doesn't trump what we did when we had that beneficiary designation. And that's really important, because one of the biggest mistakes people make is getting that beneficiary designation either incorrect, or they name a child who's under 18. And so the child can't inherit, and now we have to come to the courthouse and ask the judge to get someone, in place to manage those funds. So we give things away that way, and if we're not conscientious about how we do it, we've now maybe affected our overall estate planning. Does that make sense? Mm-hmm. So the third way is by contract. So we can give it away while we're alive, we can give it away through our will, we can give it away by contract, and the fourth is by the laws of intestacy. So if you don't have a will and you don't have a payable on death, Texas law says who's going to get your stuff. And I will tell you, not a lot of people like the laws of intestacy as the first choice because, first of all, Texas may not agree with your wishes, okay? For example, we have a lot of blended families. So if I'm married and my husband has a child from a prior marriage and he dies, the house we bought in our marriage is now owned by me and owned by his child. And a lot of people don't know that. And so when they die and they're married, a lot of people come to my office and they're like, but I'm the spouse. And it doesn't matter because Texas law says child is the beneficiary of certain community property. So the laws of Texas are going to govern what happens. And the process to get the law in place is actually the most expensive way to do it. So contract is very important, having a will is very important, giving things away in your lifetime can also be very, very beneficial. So we're going to talk about all those different things and the ways that we administer an estate. Any questions about that part? Make sense?
Yeah.
Awesome. Okay. So here are the different types of administration. So when we talk about probate, you're going to see 7 whole different choices up here. We can have something, and I'm going to go through the list, but then we're going to talk about what they are. Okay, first we can have an independent administration. That basically means you have an administration and the court does not have to oversee it after someone's appointed to make decisions. Right? We don't have to ask the judge for anything beyond the initial appointment. Then we have a dependent administration. Once we get appointed, the person appointed can't do anything without court approval. That's pretty expensive. We try to avoid that. The third is an heirship proceeding. In an heirship proceeding, we're asking the judge to make a determination on who the heirs are under those laws of intestacy we talked about, right? Just the fact that you have children or you have a spouse is not enough. We have to have a court write an order that says this is who you are married to and this is who your children are, and there's no one else out there that we've missed. You can imagine the fun we have with lost babies, adoption records. It gets pretty complicated. All right, then the next way we can pass is through an affidavit of heirship. There are certain administration where we can sign an affidavit, get a couple of other people to sign an affidavit, and on certain types of property, this is all we need to do. All right, and the next one is through a small estates affidavit. That's an affidavit we can use when there's no will, and all of the assets except the house are under $75,000. So it's nice for small estates. Less expensive than probate. It's super easy. People can even do that one without an attorney. So there's some really good benefits to the small estates affidavit. This one here is a muniment of title. And I promise we're going to go back through them so you don't have to furiously write. There's notes in there. A muniment of title basically means we're going to ask the court to put an order in place that settles title on real property when that's basically the only asset. Okay? We'll talk a little bit more about that. And 7 is a full probate. This is what everybody thinks of. We bring the will, we get the executor appointed. That executor can then go collect assets and distribute them. All right? So let's kind of walk through what these are. So we're going to talk about first an independent administration. And this can apply to lots of different scenarios. We always want to be independent of the court supervision because if you have to pay an attorney every time you want to collect an asset, pay an electric bill. I mean, think about all the little things we do. If someone dies, we have to cancel their cell phone. We've got to cancel their internet. We've got to talk to their insurance. If you have to pay an attorney every single time you need to do something, it is going to get costly very quick. And I am an attorney and I like to make money, not like this, okay? It's not nickel and diming an estate for all of this work. And the thing is if your will doesn't say that your executor can serve independently, or if you have to have the court determine who the heirs are, you have to get all the heirs to agree that this is okay. And I don't know what your family history is, but what I can tell you is it's not always easy to get everyone to agree that one of their family members can serve without any type of supervision. So when it comes to money, people get really, really concerned very, very quickly.
I've been married for 11.
So if we can't do an administration independently, we're stuck with this dependent thing. And it can happen a couple of ways. If the judge realizes there's lots of conflict, they can appoint an attorney to come in and the estate will pay that attorney to serve as the administrator. That's also very expensive, so we like to avoid that. So that's a court-appointed administrator. If the estate is upside down, though, this is a beautiful thing. If the estate has more debt than credit, there are, and I'm not going to go through the laws with you right now, but there are laws that allow us to notice a creditor, to require them to do a very, very, very difficult to do, and almost no one can do it, response with the court, and then after a certain time, they're barred from coming back. Okay, they only have so long if they don't bring a claim. So we can get rid of a lot of the debts, and many times we can put money back into the family member's pocket by using this. So this is not always a bad thing. Okay, and I'll tell you that reverse mortgages are one of those things where sometimes we need to, if there's reverse mortgage on a house and we're losing all the equity and the cost to sell a house is going to be more, we can deal with that and the other estate issues by doing a dependent administration. And so of course if the heirs don't agree, this is what we're stuck with. It's a lot more expensive and it requires a bond. So I'm going to talk a little bit about a bond. If you have a will at home, you should look and see, especially if it's not a Texas will, to see if it says there's no bond required of my administrator or my executor, okay? The reason is because a bond, you probably heard this more like in the criminal context, right? Like you have to post a bond when you commit a crime and that's your promise to appear, and if you don't show up, we can cash in that insurance policy and use all that money to come track you down, okay? Well, a bond is kind of like buying an insurance policy. So what happens is all of the cash assets in the estate get totaled up. So let's say there's $500,000. That executor, the administrator or the executor has to qualify, their credit score has to qualify for a bond, an insurance policy for $500,000, and each year they have to pay the premium on that bond. And the premium is based on the credit score. And sometimes, I would say about 40% of people don't qualify for a bond. Because if you can't manage your own finances, it's pretty hard to get someone to insure you to manage someone else's. Okay? So we try to avoid that bond. So if you have a will at home, make sure it says no bond. Okay? Only 4 states have that allowance. So if you have an out-of-state will, that you might think about redoing that will to make sure that's included. All right? So we're going to talk a little bit first about the heirship proceeding. So in an heirship proceeding, this is what we use when someone does not have a will. There are assets to administer. So keep in mind, if someone doesn't have assets, we don't need to do anything, right? We don't have to get an administration. We don't have to probate the will. So we're only talking about, is there a need to administer the estate? The answer to that is yes, there's stuff to clean up. Then we talk about these proceedings. So here we're talking about an heirship. We do this when there's no will. The court is going to determine who the heirs are, and again, that administration we've decided is going to be important. Second one is the affidavits of heirship. This is really common when the only asset is a house. So affidavits of heirship in Texas are kind of an interesting thing. A lot of people call my office, they're like, look, Dad died 20 years ago, Mom died last month, we've got a house, it's paid off. You know, we don't have cash assets to pay for an administration. We don't have things. So you always tell them, go to your title company, have them open title. If the title is clear, they will do these affidavits for you as part of your house sale cost. You don't have to pay a lawyer, all right? And they will be able to handle it for you. But if there's other stuff, it's not going to work. But here's the thing about affidavits of heirship. A title company is not required to take them for 5 years. And what an affidavit of heirship is if I'm deceased, okay? I don't like to kill other people, I just kill myself. If I'm dead, then I have children, then my children can all sign an affidavit saying, my mom is Carrie Graham, and she was married 1 time to our father, or 5 times to different people, whatever the case may be. And her children are these 3 people, and they're all above age. She died without a will. They sign it in front of a notary. Then they go get 2 people who's known me for a long time through my childbearing years to sign an affidavit as well. We knew Carrie Graham. We know she was only married 1 time, and it was to her husband, and these are her children, and they're the only heirs, and there's no children out there that we're aware of except these 3. We file them with the real property records, and we're done. After 5 years, title company has to accept that. Whether or not they accept them sooner than that is up to the title company. So I will tell you that title company shopping is really important. One title company may not do it, another title company may, okay? And having a title company that has full-fledged attorneys in it, not just like a fee attorney, they're really good at this. And they can save all the cost of lawyers, right?
This is only if there's just a house.
Only if there's just a house.
bank account in the house, you can't do this.
Well, if there's a bank account without a beneficiary designation. So a lot of times there's a bank account, but maybe it's jointly owned with someone, or there's a payable on death. So if that's in existence, then you're still good because you didn't need to administer the bank account. Does that make sense? Any questions?
This is only special in Texas, or doesn't matter?
This is a Texas law. Everything I'm talking to you about today is just Texas. That doesn't mean other states don't have something similar, but I am a Texas lawyer, so I will kind of stay in my lane. All right. Nice thing about this is that you don't have to have an administration. We keep our costs down, and usually there's no will, but some title companies will actually do it with the will, but they file the will as well. Okay. So you don't necessarily have to have no will. It's really more important that you have no assets. And that's the title company's discretion. Any questions about that? I mean, most of us want to die not using those because we want to have more assets. We just want to go to state plans. We're going to talk about that at the end. The goal is not to, well, I don't know. My goal might be to just leave no money and go on vacation until I'm gone. The next one is the small estates affidavit. So this is like not as easy as the affidavits of heirship we just talked about, but it's way less work than a traditional probate. Certainly way less work than a full-blown heirship where the court has to do so much. So in a small estate affidavit, the first thing you have to know is that you cannot have a will. You cannot lie about having a will. You just have to legitimately not have a will. So my loved one didn't have a will. If you're in Fort Bend County, there's forms online. So that's nice. Another nice thing is you don't really need a lawyer for this one. Now, you can't really practice law if you are, if you're not an attorney. But I think in Fort Bend County, if you are the only beneficiary, like a spouse or something like that, they will do this let you do this without an attorney. So after that, it really could depend on which judge you have. But this is a process through the court. Your estate has to be under $75,000, excluding any exempt property, which is typically like a house and a car. Okay? And every distributee, the people inheriting, have to sign it, plus 2 disinterested witnesses. So it's kind of like those affidavits of heirship, right? Except that we actually give the court a little more information about what the assets are. And then every beneficiary has to sign it, or every distributee. And then also you still need those 2 disinterested people to come in and say, no, this is accurate. And what you do is you file that form with the court, it has to sit, and then the judge signs an order saying this is what's in the estate. Okay? We're not really administering much. And the tricky thing about this is that if you have a bank account with like $35,000, the bank may or may not take the small estates affidavit. There's no requirement because there's no determination by a court that what you said is accurate. The court is just approving what you've presented. And so some entities will take it, some entities will not. So what I tell my clients is you need to go to those banks. I'm going to show you the form. I want you to ask them if they will take this form, and then find out who you talk to so we can go back and see that same person, right? Because if that person quits or walks away or told you wrong, we've spent money. There's filing fees, you've done some stuff, and now we're just starting back over with a full probate. And then you can't do this for 30 days until someone's passed. Any questions about that one? Okay. And the last one we're going to talk about is a probate when there's a will and there's a need to administer the estate. And we're going to take that will to the court. So I'm going to talk a little bit about the will. And I think a very common misunderstanding that I see is a lot of times people will say, but I wrote a will. Why do I have to take it to the courthouse? And people get frustrated because it becomes public record. It was filed with the court. Anybody can see it, right? And why do I have to pay money? They left a will. Isn't that the point? It's really not. So what a will does is a will nominates someone to serve, and it tells us what your last wishes were, right? It's called a last will and testament. And when you have that will, what the judge does, the judge is going to agree that you are qualified to serve, okay? They're going to review the terms of the will. And then they're going to authorize you with a letter from the court that says, hey, this person can go touch every asset their loved one owned. And that's really important because if I just take a will to the bank, they don't know if that's a valid document. They don't know if, Carrie Graham really signed that. And people forge it. This is not uncommon. Every day people walk in my office and they've lied, they've stolen, they've cheated. So, as I will tell you what I tell a lot of people is that laws are never here for the good people. Okay, they're here because some people are just very, very, very naughty, and that's just the truth, right?
That's a
And
very good
so
way to
because
put
we
it.
have naughty people, we have the probate process. And the banks and the entities that you deal with, they feel so much more comfortable when you have a letter from the judge saying, you are authorized, you are appointed, right? And then that person now can go do everything they need to do with that letter from the court. And so probating the will is a really important step. Another really important thing to know is if you don't probate that will within 4 years, it's really hard. Okay, you have 4 years. And if you're appointed as the executor and you don't probate that will within 4 years, you have personal liability, so you have to be super careful. All right? Your duty, if you don't probate it, maybe there's no reason to, your duty is to put it on file with the county clerk. Okay? We don't think we need to probate this will, and so we're going to put it on file with the clerk. So if a creditor comes back, if there is, a mineral interest inherited, anything like that, we now have protected ourselves as the executor, put it on file, and now we can come back in good faith, say we didn't know. Now we have something. Now we need to talk about, those next steps. And then no bond as long as your will says that.
So the executor can also be a beneficiary?
Yes. Commonly, that's usually the case.
Okay.
And the executor has a very strong fiduciary responsibility in Texas, not to just look out for their interests, but to protect the interests of the beneficiary. And this is, in my opinion, this is where picking a good attorney comes in, because I've got a situation right now where the executor went and cashed out all the stocks. And when you cash out stocks, you have a big problem. You have a big tax problem. Now the estate owes taxes. So instead of saying, okay, I've got, for round numbers, $900,000, and each of you three, we're going to roll over $300,000 to your name, they just cashed them out. And now there's huge tax owed. Now that executor has some liability for that choice. And so having a good attorney is going to be important because they should be able to protect you. And to be really clear, the attorney is representing you, not the estate. They represent you in your capacity as the executor. And that's another common misunderstanding, is the attorney doesn't represent the estate. They represent that executor, unless they are the executor. And some of us get appointed to serve as an administrator and executor, and then it's a little different. But the attorney really represents that person. So if you're involved in a probate situation in your family, and you're also talking to this attorney, keep in mind, they don't work for you. They don't work for the estate. They work for that applicant who's applying to be the executor, or they work for that person who's been appointed. Does that make sense? So understanding the role is important.
How does typo or typographical errors, work in a will? For example, I have a will that was drafted years ago. I know I need to redo it. And I was looking through it recently when I signed up for the class. And throughout the will, it refers to my wife.
So,
I don't have a wife. I have a husband.
right.
And we're still married. No, which is fine. Commenting on that is just truly a typo.
Yeah.
But throughout it, it says, Sudi Patel gives to her wife, through the whole will. It's just a typo. It was probably a bad cut and paste job by whoever did it 10, 15 years ago, who was a lawyer, but we won't say her name. So anyway, does that really matter when you go to probate? Because they know that my husband is a male. I have a marriage certificate, or do I need to redo that whole part of it?
So,
Or can I just line through it?
no, you cannot
Okay.
interlineate on your will.
Like initial it and put his everywhere?
You can't.
Okay.
Don't
I don't know, I'm
interlineate on your
asking.
will, because
Okay.
when you start to interlineate, you affect it. We don't want to do that.
Even for pronouns?
In your case, that is probably no big deal because he's named as who he is.
Yeah, his real name is in there, but then
Right.
in the body it says my wife.
Right, so
So it has
probably
been-
not an issue for you, although the judge would have discretion. Maybe he'd want everyone to sign off on something, but probably not.
Okay.
My gut would be no. Where it would be an issue is what if it just said my wife all the way through it and didn't name him?
Oh,
And then we have to bring a reformation before the court to say, Judge, this says my wife, it was an accident. And I've done a couple of reformations, and what we do is we try to grab that drafting attorney and get their records so we can prove it. Because I've had cases where the residuary clause was left out, and it says, if I give, there's nothing that says I give all the rest of my estate to X. It'll say my house goes to my 4 kids and my Charles Schwab account goes to my 4 kids. But when someone dies, they have other things like vehicles and other investment accounts or an inherited IRA. And there's nothing in the will that says, and everything else I give to my 4 children too, right? I've had 2 cases this year, well, 2019, 2 cases where the residuary clause was left out. And so we had to subpoena the attorney, subpoena the file, get them to court, and ask the court to reform their will. And that happens too, like on names, similarly named children, things like that. Or sometimes people put like long, people from Mexico sometimes have really long names, and they're sometimes incorrect. And so a reformation is another way to get that done. They're not super hard, but it's an extra step. So worth fixing on the front end. Worth fixing.
So should fix that now.
I mean, you know,
While I'm still
the goal
alive.
is not to die, but yes, fix it for sure.
I have a question.
Yes, ma'am.
What if you have a child that is supposedly married to someone, who committed a crime against someone within your family, and this person has a child by your child, but you don't want anything left to that person that committed the crime? How do you do that?
So so that's a great question. In your will, you can write in or write out everybody. There's no duty to leave your stuff to your spouse. There's no duty to leave it to your kid. You can hate them all. You can just hate one.
Anybody, but
You can love and still exclude. I've had clients come in and say, look, this kid took up a lot of money because I paid for $400,000 worth of college all the way through medical school, and this child got a bachelor's. I want to make sure that we even that out when I die, right? We deal with that stuff. Thing you need to know is that your will can control who you give things to, but it cannot control who you give things to past that. If you want to control someone from the grave, that's when we look at trust planning. And I'm not a huge advocate of trust planning because it's expensive and a whole bunch of other reasons I won't go into unless there's time and you really want to know. But a trust is a way to control your children after they die. If you need them to marry Jewish or, I mean, whatever it is, you can do it in a trust. But in your will, we don't let you reach back from the grave and control beyond those distributions. Unless you have a minor child or a special needs adult, and then we do some trust planning like in your will.
yeah, it's kind of sticky. But yeah.
It's a little sticky, but I mean, it kind of makes sense.
Yeah.
You have a question?
This is not I guess a substantive question, but I had read some CLE that said there were some changes in the code that we're not supposed to put last will and testament of X, you just are supposed to now to say will. Do you know anything about that?
No.
Okay.
And I let my clients pick because some of my older
I
ones feel like, I do a lot of litigation, and I've never seen someone argue about what it's titled because the requirements for a valid will have nothing to do with what you call it. You don't even have to call it anything.
Yeah.
You know, in Texas, you can have a handwritten will. Don't do that. Don't do that. That's not good.
Yeah.
But, you know, we've had a will left on the back of a tractor in Texas, and it was valid. It's got to have your name. It's got to have testamentary intent. And you need to sign it. But it doesn't say you got to call it anything. So not as far as I'm aware.
Okay. I don't know, I read that in some CLE
If you
a
find
few
something,
months ago.
shoot it to me and we'll talk about it.
Yeah.
I'm kind of curious what it was talking about. I mean, it does, if you call it your will, it kind of automatically gives it testamentary intent. It could be something about that. You know, maybe there's a case or something. Any other questions? All right. Oh, that's for lawyers. You don't need to read the code. So, I'm going to talk a little bit about this. I get a lot of calls from people and they'll say, well, my dad died. We need to probate the will. And I want to come see you. So I have to ask them, are you named in the will? Because the only people who can bring an action in probate are these people. A named executor, someone who's designated by agreement by all the parties. A creditor can do it. If you owe MasterCard a bunch of money, they can come get your will and probate it and absolutely go chase down their money. An owner of the decedent's estate if there's not an executor. So if you're a beneficiary, you're an heir. So if there's no will and you want to come start the process, you can do that. If you're an heir under Texas law, you can do that. A guardian can do that, someone who's been the guardian for the decedent's estate. Or a trustee, right? A trustee can sometimes do it if the decedent was a beneficiary of someone's will. So like, let's say I have a special needs child and I'm the trustee of her estate and her uncle dies and leaves her money and there's no other family. As that trustee, I can go hunt down funds to benefit my beneficiary. That makes sense?
How do creditors find out? Like, my parents are both still alive, and I don't even know if they have credit card debt or not, but like, if they both passed away, is it my job to find out, oh, my mom owed MasterCard $5,000? Like,
It is. So
Oh,
you
okay.
have to do some things, and I'm gonna kind of pause because
sorry,
everything else is
did
super.
I go ahead? Did
No,
I
no, no, no,
mess
I'm
up
gonna,
your flow?
the
Sorry.
rest is like for lawyers, I'm just gonna kind of pause it
Okay.
and talk for a second.
Okay, sorry.
No, that's a great question. So you do have a duty,
Okay.
under Texas law to not just find reasonably, it's reasonable efforts, right? To find the creditors and to notify them. Give them notice that you're appointed. You have to notify a lot of people. Your HOA is a secured creditor, for example. Your IRS, that's a big one. You gotta send them a Form 56. There's people we have to notify. And then not only do you have to do it, but you have to sign an affidavit that you've done it. And so for my clients, I tell them, go get the last 3 months of bank statements. Let's find out who they were paying and who was paying them. If we don't know, they can get their IRS transcripts. That's really helpful. So if they've gotten a 1099 from some asset they own or rental income, we can find it. And then we look at it. I send out notices to all the, I don't technically do it, my staff does, but we send out the notices to all of the parties. We get green cards back. And then I sign an affidavit for my client saying, I gave these notices and I got these returns, and I attach that return so the judge can see this was done. And then you also have to give notice to the beneficiaries, lets them know that you're appointed and that, these are the assets of the estate. You have to give them an inventory. So there's some stuff, that you have to do. It is work. I mean, being an administrator and executor is a hard job. It's a lot of there's a lot of things you have to do. It's a lot easier in this day and age because we can do so much online. And because the entities that we deal with, like, they don't want to have to see you either. So there's a lot of processes to get you in and out with them. But it's work. And another thing you can check in your will is whether or not you want your administrator or your executor to be paid for what they're doing. I'm generally kind of against it because I'm a litigator, and I think that when you start paying someone to do a job, all people are going to do is complain. And if they're benefiting anyway, that makes sense. But if they're not benefiting, maybe you have younger children and Uncle Levi is going to come do it. Well, Uncle Levi didn't really sign on for 40 hours of work. So maybe throwing him a little bone would be all right, Questions? Okay. Yes, sir.
I heard there's another way called the living trust. What's the pros and cons of doing it?
So let's talk about trust planning. I'm not a huge advocate, and I stand in the minority. I'm just going to tell you that. There are lawyers who just love their trust planning, and I really do believe trusts have a place. But generally speaking, trusts are used to avoid probate. And in Texas, it's so inexpensive and easy to get through the probate process. It's, I think, better to have a will. I'll tell you a couple of things. I think trusts are great when you have special needs kids, because the only people who can create a special needs trust is a parent, a grandparent, or a court. And so you're free and the court is not. And that is irreplaceable to keep them on their Medicaid benefits or their SSI benefits. So awesome. Always use a trust if you have special needs kids. If you want to control your children after you die, also a great tool. It really is. If you want to have some say, if you have children who are struggling with abuse or addiction, it's a great planning tool. If you have out-of-state properties and you want the benefits of Texas law, and I actually do quite a bit of that type of trust planning. So let's, for example, say you have a small property in the Northeast where they most of the properties there have a death tax, so you get taxed on everything when you die. And so if you want to avoid that, you can make your Texas trust the owner of that property and avoid some of those things. So having out-of-state properties is great. Also, mineral interest, trust planning can be really useful. So with all those great benefits, why would I say I generally don't love them? The reason I generally don't love them is because I've had too many cases where we lose a trust document and they're located pretty much nowhere, which can actually happen to a will, but at least with a will, we have some other ways we can get your stuff done. With the trust, if you put everything in the name of the trust and then I can't find your trust document, we're kind of up that big old creek and no paddle to get back, right? And this happened to me as an attorney. I had a client actually name me as a trustee and not tell me. So when the bank said, hey, guess what, you're the trustee, and I said, what? That was awful. So I didn't love that. And also, I think more importantly, trusts are taxed at a different tax bracket than a person. And so the overall cost, depending on what's in it, you might spend substantially more money managing a trust than you ever would, for just having an outright distribution. So I'm a fan of testamentary trusts. My wills always have a optional trust for special needs children, saying, hey, look, if anyone who inherits under my will is gonna, by the IRS definition, is special needs or disabled, and they're getting any type of government benefit, and this inheritance would affect those benefits in any way, here's a trust for my loved one, so that you don't have to go try to get a court to create it. It's there. You can elect it. And when you probate my will, already in place if we need it. The other thing that I put in all of my wills is a contingency trust. And it's a contingency because the trust is only put into place contingent on the age of the minor. So my kids, I have children who are pretty far apart. They're 22, 20, and 8. They're in all of these little recordings too, which makes them so happy. But my kids are still young and stupid. I mean, I love them. They're wonderful. But they're not married. I don't know what that's going to look like, right? They're likely to get divorced. And so for my kids, sad for them, they have a trust till they're 35, so it stays their separate property because I also divorce people. And I love knowing, at 35, if they don't have it, we're just good luck, right? But I love knowing that if it's in that trust for them, that contingency trust till they're 35, if they get married, because I'm not super old, I have a lot of life insurance, they're going to get some money. If they're targeted by somebody and they get married, divorced, or whatever, or they just become bad humans, there's someone else out there who can hold and manage those funds for their benefit and protect them until they're 35. And after that, like I said, they're on their own. So that's kind of the trust explanation. So, did I answer?
Yeah,
Okay.
thank you, good answer.
Yeah.
So, sorry, the in the wills, it has like trust language.
Mm-hmm.
But this is really a dumb question, but what funds the trust? You can have the all the wills say, I hereby set up a bypass trust. There's all these words, I don't even know all of them. But what funds the trust? What makes it actually?
Like a valid trust?
Yeah.
So,
because I see that language all the time in my families. Everybody has different wills. Some have written themselves,
Yes.
some have lawyers. And everybody's got a trust. But I'm like, but what's funding it? Like, what
so nothing
kicks it
now.
in?
So remember we talked about
Okay.
how your will is a nomination. So you're really saying, I'd like to nominate this trust to be in place. But until the court orders it, it's not a trust, right? But once the court orders it, what's a very interesting, very technical, probably good for thinking purposes is when your loved one dies, their stuff vests in you automatically. You can't get it yet, but it's already yours, and that's the corpus of the trust. So it's that beneficiary's already, the court orders the trust in place, and that's the corpus of the trust.
There's not actually a bank account number associated with the trust.
Correct. So the executor then, or the administrator now has a duty
To go
do those things.
Okay.
Right.
I'm sorry, I know that's real basic.
And that can include things like getting a tax ID number, because now the trust is a person. Right? A trust is just like a person. It gets its own tax ID number. And so we have to kind of walk through all those, which is why being an executor is a serious job. And I will tell you, the thing I really kind of preach at my clients is don't think about your children in birth order. Think about their geography, think about their availability, because if you give the role of executor to a single mom who cannot miss a day of work, you have really harmed that person. Do they have the mental capacity to go handle these very complex things, to be patient, to call AT&T and sit on hold with every single thing you own to get it all canceled. This is not an easy task. It is not for the weary. And your oldest son might be amazing, and that might be who you really wish you could appoint, but they just can't do it. And so we really got to make sure when we pick that person, we're thinking about all those things, right? And naming backups, so we don't have to get the court to put someone in place for us.
And then I have a question also. So I have a son that's almost 20, and then I have a daughter that's 13. And I need to, I guess, when she was born, I did some kind of guardianship form where I put my brother as.
You
Actually, I don't even
designated
know if
someone.
she's on there. I'm sorry. I should go pull it and read it. I do have a guardianship form, but it may have been for my son, but who is now almost 20, so it doesn't matter, right? That goes away by operation of law.
By 18.
Okay. But for my daughter, I was thinking, since she still has 5 years till she's 18, just in case, you know, I die in a car accident tomorrow, I should probably put my son as her guardian, because I trust him to do it, and he's a stable mind and all that. So, and again, I'm so sorry, it's a dumb question, but like, when I draft that, am I saying that Dylan is now her guardian, like to raise her, or to take care of her money that she's inheriting?
So
Is it like a,
it's not the same,
okay, that's what I'm asking.
right? So when you designate a guardian of your minor children, that is a document, right? We love those documents, by the way, because those documents can go in your kids' school folders. And then if something happens to you, we're not trying to vet your family members through CPS. We're kind of avoiding the system, so those letters are great. They also, Texas will really honor who you say you don't want to be your guardian. And so that's great, but that's on their person. That's who's gonna be their pseudo-parent when you're not here.
Okay.
If you want a guardian of the estate, we don't wanna have a guardian of the estate because that's expensive. We wanna have that contingency trust in our will so that it could be the same person, but it's a separate appointment for who's gonna manage funds.
Oh, okay, so I would have to designate 2 people for the little one.
Or they can be the same person, but you have to designate separately. So the designation for the guardian of the person could come to the courthouse and apply to be the guardian of the estate and would have standing to do so, but now you're in a court supervised, which we don't want because that just eats up her funds. So what we want to do is have that contingency trust in our will that says something happens to me, you know, my brother Ed is going to be the guardian of her person and my brother Ed's going to be the trustee of her contingency trust, or 2 separate people, however you want to do it. But it's 2 designations, but it can be the same person.
Okay.
Anybody have any other questions? Yes, ma'am.
Do you have some more copies of the presentation?
I do. I'm gonna pass those down now.
Sure.
You betcha. Well, it is right at about an hour, but I am happy to answer questions if you have them, so you guys tell me.
I have one last question.
Bet.
In your will, you name an executor. Now, we're all getting older. Should you name an alternative executor if that person is not able?
Yes, I'm actually a huge fan of 3 or 4 backups because it can be that people's situations change. Someone gets sick. And if we don't have that in your will, if we don't have a backup, either all the beneficiaries have to agree or we have a problem and we have to go down that dependent. Remember that dependent path where we have to ask the court for everything. So it's really important to have lots of backups. And then since I have maybe a minute and a half, I'm actually going to talk about something I'm super passionate about, which is your financial power of attorney. This is a really important document because as much as all of your stuff is very important, you're dead when we deal with your will, right? While you are alive but incapacitated, this is probably the bigger part of my practice in litigation, the stuff that happens. People have bad powers of attorney, forms from the internet. I mean, powers of attorney are really, really important, and they need to address really specific things, and they need to be extremely clear. And so having a good power of attorney is important. So if you have one already, go home and look at it. You should look for a couple of things. First of all, did you name backups? Second, is it a durable power of attorney? Does it endure past your incapacity and disability? Third, is it current? Because we had a lot of changes in 2017. And here's the thing. We never really had a law in Texas until recently that says anyone has to accept the power of attorney. And the problem with the power of attorney is it can be perfectly valid, but if you drafted it or an attorney drafted it and they did not know what all banks require and title companies require and all these things, you can have a perfectly valid, useless document that no one will accept. And that's a problem because now we're getting a guardianship and we're spending thousands of your dollars on court costs and not on you, and that's bad.
Yeah.
Okay, we don't like that. So when we've got this law in Texas now that says you have to accept it unless a whole line of things happens, and the last one is you don't really feel like it's a good idea, basically. So we really don't have a law in Texas, and so your financial power of attorney is truly irreplaceable. People only will take an original, right? So that's really important. If you have real property, that needs to be specifically addressed and not as an exhibit. It needs to be in one of your hot powers, which is like a list of special things your agent can do. And if you ever think you might want to utilize Medicaid benefits, and I say this because I help people protect assets and qualify for Medicaid nursing home benefits, you got to have the right language in there, the right gifting language that complies with Medicaid, and you not just that little thing that says you can apply for benefits, but I draft like a whole paragraph on Medicaid language, because if it's not right, you can't protect your assets. And now you have to specially authorize also trusts when there's a special Medicaid trust. So we would like to have that as well. So your power of attorney, I feel like, I'll just tell you, I don't feel like estate planning is something every lawyer can do. So when you go look for a lawyer, make sure they litigate their documents, make sure they do real property stuff. Because it seems simple, go write a will, it's not that simple. And if you don't have it right now, it will cost you a lot more to fix it later. And so the best advice I could tell you today is just make sure you have a good estate plan, and make sure that whoever you're talking to talks to you about your beneficiary designations, your life insurance, your long-term care, because you need a plan. Because once you're gone, we're not worried about it, but your last years on this planet, we want those to be pleasant and we want them to be wonderful. And that all needs to be addressed when you start your planning.